Hello, everyone, and welcome. This is another of our blog podcasts about later life divorce. So myself, Jacqueline Menser, lawyer at Bennett Griffin, family lawyer extraordinaire, and also my colleague, Sarah Pennicott. Hello, Sarah. And we're joined today, we've got a very special guest. We've got barrister counsel Trina Little.
Hi.
Hello, Trina.
Hello, hi.
Trina, you're with Westgate Chambers in Brighton.
I am indeed, yeah. I've been there for 13 years. So, yeah, part of the furniture.
Brilliant. And so you've got obviously a wealth of experience in terms of high-level financial cases, divorces, right across the spectrum.
Yeah.
And I know also looking at your profile, you also deal with children's arrangements orders, contact issues.
Yeah, I do. It's sadly, or perhaps not so sadly, but they do tend to dovetail. So if people are arguing about the money, then they can also be arguing about the children, which is quite sad. But yeah, so I do sometimes I will represent the same person through both of those sets of proceedings. So yeah.
Okay. And also I noted another topic that we've touched upon previously, cohabitation and financial issues arising out of living together.
Yeah.
Because obviously that's on the rise.
Yes. Yes, and that a lot of those cases are with the benefit of hindsight, because they find themselves up in the in proceedings because there's been some potential agreement, or they've not quite finalized things, or they were in love, so they were never going to this was never going to end this way. So yeah, do the whole spectrum. Yes.
Okay, well, we're glad we've got you for your expertise, because that's definitely something that we like to consider in a different way. There's lots of aspects which obviously are similar to divorce cases, but where you have those that have lived together before, there's special aspects. So we know where to go if we need you in terms of further advice. So thank you for that. So in terms of the series that we're producing at the moment, it's specifically in relation to the increase in divorces for those of a later age. Now, we could be delicate about that which is a later age. We will say over 50, we will say over 65, and we will hope not to upset anyone because we're just talking about later life divorce. We've got a few statistics. I was having a look at the Office of National Statistics, and the census, which is for everyone to have a look at of 2021, refers to those who are of a later age, who are separating, as silver splicers or silver separators.
Splitters, silver splitters,
silver splitters, which is quite novel, and sort of all sorts of interesting facts which sort of coincide with the fact that people are obviously still getting married, people are remarrying, and it's quite a phenomena that there are so many people who are marrying again, perhaps serial marriages, and then they have considerations about pre-acquired assets, older children, and of course then that links into inheritance and all sorts of other issues.
Yes, it does. And I wonder whether, because I've got a number of cases with people in their 80s who are getting divorced. And you would think, oh gosh, you've hung out this long, why now? But actually I wonder if there is certainly a sense perhaps of wanting to get your house in order, wanting to make sure everything's sorted, and there's potentially inheritance issues. And I wonder, as people get older and the children leave home, there is that sort of sense that actually empty nest syndrome, and actually now it's time to, we've hung on for the children and now they've got their own lives. Maybe there is a sense of actually, well, I want to do something for me.
So absolutely. And I think that may also, and I think that may also be a cultural or a socio-economic change that maybe has happened over the last 10, 20, 30 years. Whereas previously, perhaps, at the risk of generalising, people would sort of just put up, wouldn't they, make do and see it through. Whereas now they do feel that they're actually entitled to have a new lease of life.
Absolutely right, yes. But it's definitely, as I say, it's definitely on the rise, and I've seen that with my own practice.
So looking at the stats, and I'm sure you'll agree with this, Sarah. So the stats seem to say that, for instance, a quarter of the divorces nowadays are for those over the age of 40.
Yeah.
That there's been a 64% rise in divorces since 1990 of those who are over the age of 65, I believe. And other stats, almost 92% of those who remarry, or those who get married after the age of 65, and this was a statistic in 2014, so going back some way still, so there's obviously quite a trend on the ascendant, that those who married over the age of 65, 92% of them had actually been either divorced or widowed. 92%. Only 8% were marrying for the first time.
Interesting, yeah.
So they're bringing with them, so we're all bringing with us a huge number of issues from those previous lives.
Yes.
Well, the cases I've got at the moment, obviously I can't give any specific detail, but they are both, the two that I've got active at the moment, they are both remarriages. They were second marriage that are now divorcing. Yeah, so there is all that, you know, I want first family to, you know, have money, the inheritance and so on and so forth. So, yeah.
And do you find, I've got matters whereby it's almost health scares have triggered them to think, right, I need to sort out my financial affairs so that I'm not particularly happy in this relationship. And that's prompted it to ensure that their children do receive what they want to. I know they could do wills and trusts and so on, but in a couple of my situations, it is those health scares that have prompted them to think, actually, let's just go our separate ways and make sure that our property goes where we want it to.
I think that's really true. Yeah, because it does make you assess.
Yes, yeah. And I think so we've tried to sort of look at the questions we commonly get asked, and I think talking about previous marriages or whether you're widowed or divorced, but second marriages do bring pre-owned property and pensions, particularly where it's accrued predominantly outside the relationship and then suddenly it's drawn into the matrimonial asset. And I know a lot of clients' first concern is, will I get to keep what I bought to the marriage? And that's a big concern, particularly in later life divorces, I think.
I think it's solely facts. Everything is fact specific. So obviously, if you've been married before, you brought perhaps a property or, as you say, a pension to the new marriage. It would solely depend, in my opinion, on whether it's a needs case. Obviously, if it's what's called a needs case, then essentially everything goes on the table. If it's about one person needs care home fees, for example, or needs somewhere to live, the court will and are able to look at everything available to the parties. There are ways to get around that by sort of, as you say, you know, you can do, there are things, prenuptial agreements you can do. They're not binding, but they will certainly, the courts will take them into account. And there are certain ways to ring fence assets. So you can say, well, this is pre-matrimonial accrual, and particularly for pensions, for example, if you've got, say, pensions that were accrued after separation, for example, you can say, well, look, that's not part of the matrimonial assets, but it's all completely fact specific. But yes, there are ways to look at those assets. But as I said, if there's, I know we're talking about later life divorce, but if there are dependent children, for example, then the courts will need to, they are the primary welfare of the court to make sure that they are housed securely. So I can't give you a definitive answer, but yes, there are potentially ways, but it depends on the situation.
Yes, yeah. And I think another question we get, or I've got one particularly at the moment, is where one person has pension income which is larger than the others. What do they do in the interim whilst one can afford legal costs, the other one can't, and they're in a real position of unfairness at the moment. And for that person with a lesser income, there's a real fear of how do they get legal help? What do they do? Yeah,
well, there's two ways to actually consider in that situation. There is a thing called maintenance pending suit. So you can actually apply to the courts for an interim order for maintenance to be paid. You would need to provide a budget for that, so the courts will look at actually what's your incomings, what your outgoings. But there are things called litigation loans. I don't know whether you use that for your clients, but there are ways to fund these proceedings, because it's not fair and not right that one person can fund, you know, counsel, solicitors, etc., and the other one has to appear in person. There has to be an equality of arms. So there are things like litigation loans out there that you can access, and they will look at the circumstances and work on the basis that you will be getting some money at the end of it. There is an interest rate to pay. I can't tell you exactly what it is, but I know there is an interest rate to pay. But ultimately, if that's the only way of getting the end result, because I would say as soon as any of these sort of proceedings are contemplated, I would really urge people to get legal advice, financial advice. And I know people get worried about costs and things escalating, but actually by spending money in the very beginning, and I've had many cases like this where by having instructed counsel, instructed solicitors very early on, we've come out with a much better result than they would have done had they not have done that. So that would be my recommendation, certainly.
And coupled with that, it's not just the financial costs, is it? It's the time. You get counsel and you get solicitors on board early on. You get sensible advice. You can negotiate more sensibly, and you're more likely to achieve an early settlement.
Yes.
And there's the human cost associated with that as well, isn't there?
Oh,
the stress of the ongoing proceedings.
Yeah, I don't think that can be underestimated. It is so stressful. And actually, particularly for people in later life, I think, you know, it's such an upheaval for them, having to move out of the family home, potentially, if that's going to be sold. And the stress involved is it can't be underestimated.
No.
Going through any divorce, whether it goes through court or not. But actually, as you say, if you get the right advice from early on, there is a good chance that you can settle it without having to go through the court proceedings. So I do lots of advising in conference. So a solicitor will say to me, this is the situation, what do you say? And I'll have a conference with the solicitor and the client, and I'll be able to say, this is where I think we'll probably end up if we go all the way to court. And that gives the solicitor and the client a really good steer on where they should be, sort of in terms of negotiation. So, and then it's lovely. And then I don't hear from them, or it's settled, and that's great. But you know, inevitably they don't all do that. But it's I think that I've seen that work so often in the past. But sometimes, as I say to my clients, you can only do so much if the other side aren't willing to come to the table. There's nothing you can do. So. No. Sometimes you do have to go into proceedings, and sometimes they do go all the way. But I've been successful on sort of cost applications by people's litigation conduct. But I think you're absolutely right. It can be very stressful.
Yeah, and at the moment, with the court delays, they have got significant delays. I think proceedings are probably taking between 12 and 18 months. Do you think at the moment, and so people often, again, we have to look at the alternatives to going to court. It's not the first, it's the last port of call, really, isn't it, for time and stress. So we can refer people to mediation, but there's also other sort of alternative dispute resolution avenues that people can explore, which may be better suited to later life divorces as well, I suppose, in a lot of situations.
Yes, and I think I could add something there, Sarah, because I'm qualified as a collaborative lawyer, and obviously as an alternative route, collaborative law is all about supporting and comforting people, so being in that safe forum, and obviously that applies to anyone regardless of their age. But I think if there are additional sensitivities, because the prospect of going to court is so daunting, and just meeting with lawyers can be, you know, a scary thing, even though we are very down to earth and approachable with that, having that safe situation in which you know you've got support immediately, and the pacing. I think that's some of the issues with going to court, apart from the fact there's delay in getting to court in the first place. It's the pacing and feeling that things are running away from you, rather than having that input and control and that power. And obviously the alternative routes do offer you that, because you can decide on a mutual basis what's happening when.
Yeah, and I've seen mediation work so brilliantly, and sometimes we do adjourn off for parties to mediate. We sometimes adjourn off for private FDRs. That's very much something that's on the increase. I've seen certainly in my own practice. If the parties can afford it. It costs a little bit more because you have to pay for the judge, whereas obviously if you go through court, you don't pay for the judge. Whereas this way you pay for a judge, but on that basis, you know, you're going to get someone who's going to be solely focused on your case for the day. They would have read all the papers, they would have got all the bundle, and they will actually really be able to dedicate a lot of time to it. Whereas sometimes when we're in the court process, they might have 3 or 4, maybe 5 cases listed in that day. So they can only do what they can do, and they're brilliant. You know, we're very blessed with our judges, but they can only do so much with the time they have to allocate it to everybody. So definitely a rise of private FDRs, and they've worked really well, I have to say. I've really, as I say, I've noticed a big uptick in those, and that they've been really successful. So I wonder whether that's the way we're going to go. And obviously with that, it foreshortens matters, because you don't have to wait perhaps 6-9 months for an FDR hearing to come through. So you'll get that hearing quite quickly. I don't know if you want me to give a brief overview on what happens in terms of the hearings in divorce for people who are watching.
That would be really helpful.
Yeah, so what you have, the first hearing is called an FDA hearing, and that's essentially a directions appointment. I've noticed since COVID, a lot of those now are agreed. I don't know if you found that now, because they're fairly standard directions. So unless there's something unusual, they can be agreed, which is good because it saves costs. Obviously, it saves court time. But on that hearing, they will have things like, they will direct the parties to go and get property particulars, what of houses they think they could live in or flats they could live in, and same for the other party. They will ask them to get mortgage raising capacity. So have they got any mortgage ability open to them? They will ask for sort of updating disclosure, so provide bank statements, etc., and that sort of stuff. And so there's just a load of general directions that will happen, and they'll be given dates for things to happen. If there's going to be a pension sharing report, so if one party has got a significantly higher pension than the other, for example, I would always lean in favour of getting an expert involved. Pensions are an incredibly complicated area. And it's not just a case, it doesn't work on a pound for pound basis. So you can't say, well, you've got £100,000 in pension, I'll give you 50 grand and, you know, we'll offset it. It's a lot more complicated than that. And so if we're going to have a pension report, we would ask for that at the first hearing, and that can take a number of months. So that will potentially delay things. But if pensions are a live issue, it's really, really important. And so then when we have that, what we do then is we move to the next hearing. When we have all the information, it's basically an information gathering exercise. So then when we get to the next hearing, which is called the FDR, which is a dispute resolution appointment, and this is what I was referring to, private FDRs. And what happens on that occasion is it's called a without prejudice hearing. And so you go before the judge, you say to the judge, this is our position. My client thinks they should have X amount. This should happen to the pensions. This is what should happen to the matrimonial home. And the judge will give, and they'll hear from the other side, obviously, and then the judge will give what's called an indication. As I said, that's not binding, so you're not stuck with that. But what happens then is, I always tell my clients, it's listed for an hour, but we're going to be there all day. And then it's like a mediation where we basically spend the day negotiating, but actually being in court focuses minds. And they hear what a judge has to say. And the judge will say, if this goes to the next hearing, this is what's most likely going to happen. This is going to be the outcome. Either, you know, the house will be sold, or there'll be a pension sharing order, or one of the parties will get slightly more than the other, or whatever the circumstances are. And so that's really helpful. And most cases settle at that time or shortly after. I've had cases where we've spent a long day negotiating and parties can't quite get over the line, but actually once they've had a good night's sleep and it's a long day and they have some time to reflect, they then settle it very shortly afterwards. Some cases just simply don't settle for various reasons. Maybe the parties aren't quite ready, or they don't accept what the judge has got to say. And they think, actually, if I get to a final hearing, I think I've got a better chance of getting more money, for example. So then it is listed for a final hearing. And then that hearing is what's called a contested hearing. So it's at that point, because lots of my clients go, do I have to talk? Do I have to talk? And I'm like, no, you're paying me to talk for you. But it's when you get to the final hearing, that is when parties will give evidence. There'll be the dreaded cross-examination. And if there are any expert witnesses, for example, pension expert or a surveyor who's valued some land or whatever the circumstances are, they will give evidence as well. And then the judge will hear all of that evidence and then will make a final decision. And then that decision is binding, whether you like it or not. You're stuck with it. So I think the courts really very much take the view that if you can try and sort things out before you get to that point. And I say to my clients, nobody should be, after any of these hearings, you know, the FDR or the final hearing, nobody should be skipping off into the sunset gleefully, you know, high-fiving. The reality is everyone's going to come out feeling probably a bit disgruntled. And that's just the nature of it, because you're going from one household and you're having to split it. So you might not be able to have the holidays you had, you might not be able to have the size house you had, or you might not be able to drive the car you did. And compromises have to be made. But I'm afraid it's just the nature of the beast. But actually what it means is that people can then move on with their lives. And sort of move forward, and they have to readjust. There is, you know, that's just a period of readjustment that they have to get used to. But yeah, so that's the sort of three main hearings. There are sometimes other hearings, but I won't. They're very, as I say, fact specific. So I won't go into too much detail there. But you should be expecting 3 hearings. As I say, the first one you don't necessarily have to have unless there's something sort of unusual or needs to be aired in front of the judge.
Thank you, Trina. That's really helpful as an overview. Now, you've highlighted some of the benefits of actually being at court, so physically being at court and having the ability to speak to the other party, their lawyer, having that time to negotiate, basically the judge saying, toddle off and try to agree this, you can come back, I'm available to hear you again, you can reach an agreement. What if you get a situation in which it would be preferable or desirable for the clients not to be physically at court? Because obviously now we're seeing the rise, we did since the pandemic, see the rise of remote video or CVP court hearings where you're not physically actually at court. Could that be advantageous to, say, clients who are a little bit older going through divorce, who might be a bit more sensitive to being at court? And I'm generalising.
Yeah, I think that's a really interesting question. And one of my cases we did remotely recently, just because he was physically unable to come to court. Having said that, during the pandemic, it was very difficult. Cases that should have settled didn't, because people were sitting, you know, in their front room or, you know, having their lunch or whatever. They just don't take it as seriously as actually being in front of the judge, hearing what the judge has got to say in person. So I would really advocate for people to come to court, not necessarily for the first hearing. If you're having a first hearing, I'm all for it being remote. And I think certainly our local judges agree. But certainly for the next hearing, the negotiation hearing, I think it's really important the parties come to court. Having said that, if there is a physical reason that they can't come to court, of course, then the things can be put in place. And even if you do come to court and people are anxious and there could have been a very bad ending to the marriage, or, you know, there could be a history of abuse, there are things called special measures that the courts are very alive to. So you can have things like screens in the court, so you don't need to see the other party. Sometimes they do live links, so you're in the court building but you're in a different room, you know, so you can do live links, that sort of thing. So the courts are so used to this now. Certainly when I started, it was a bit of a rarity, but actually it's quite common now to say, oh, my client would like a screen. That means that we go in first, we get into place, then the other party come in. The other side's not only, their barrister, for example, will be talking, so they don't even need to hear them. So there are lots of things that can be put in place. You can have separate entrances, so you can come into the court via a separate way, so you don't have to bump into your ex. There's lots of things in place that, so, you know, you don't have to sort of be, but you don't have, it's a stressful situation. You don't, you know, they try and make it as, you know, they try and put things in place to make it as less stressful as possible. And they're very, as I say, they're very good at that now. But I would advocate that if you can get to court, great. But there are circumstances, I mean, even logistical reasons, sometimes you just think, like, if you're far away or whatever it is, you just can't do it. But yeah, but rest assured, if you do have to come, you can bring someone with you. If you want to bring a family member, for example, they're not allowed into the court hearing itself, but they certainly can come and support you prior and post the hearing. So that's sort of reassuring for some people to know that they've got a friendly face with them. So yeah, I'm sure it's a very common feeling to feel that way, but everybody will do their best to make people feel reassured. Sort of the courts want to hear the evidence. They want to hear the best evidence they can, and they will ensure that they put whatever they can in place to make sure that that's heard.
I've recently had a matter, not with a later life divorce, but that it's listed for longer so that the person could have appropriate breaks throughout the hearing.
Exactly.
And so if we've got somebody late to life with health needs, then it might be that it's listed for a longer time estimate.
Yeah, exactly.
To give them those allowances to make sure that they can attend to their health needs as well.
Yes, absolutely. Yeah, loads of measures can be put in place. We do sometimes do hybrid hearings. So if the person can't come to court, they can be supported if they're at home I had one recently where the solicitor sat with the client and I was remote, or sometimes I've been in court and they've been remote. So there are ways of doing sort of a hybrid situation rather than everyone being in court or everyone being remote. So I think, in a way, lockdown's been a blessing for that, actually, to give a bit more flexibility for people. So
yeah. Very true. Now, Trina, when I asked you that question, I knew you'd more than know the answer, because I saw from your profile that you've got a specialism with vulnerable witnesses.
I have, yes, I'm vulnerable.
Yes, which is great to know.
Yeah, I like to, and I like to think that it's when you meet clients, sometimes I don't meet them. Sometimes I have conferences before. Sometimes I don't meet them till the morning, and I say, right, turn up an hour before, and I'll meet you. And of course, they're so worried about what's going to happen. I do this day in, day out, so I'm very alive to that fact, and I'd like to think that I'm sort of very conscious of how they're feeling and trying to put them at ease sort of quite quickly. You might only have a few minutes to kind of get through that barrier and sort of go, look, I've done this before, you'll be fine, this is what's going to happen, just giving people the confidence to know that they will get through it and there is light at the end of the tunnel, and it is a process. They've just got to get through the process of it. So
that was a big reason why we started doing these vlogs in the first place, was to sort of show that we're not sort of scary people. We're quite approachable, and just to kind of give people an insight more into what is actually involved in these things that seem so alien to them because it's not part of their everyday life. And so but it's been brilliant to speak with you today and sort of get a bit more insight into your side of it and the support that we can give to all clients, but particularly those in later life throughout the process. So thank you.
Oh, well, you're very welcome. It's been really enjoyable speaking with you both.
Thank you so much, Trina. It's about teamwork, isn't it? It's us all working together as professionals for the benefit of our clients.
Absolutely, and I say that to all my solicitors. I'm really happy. I know some of my solicitors say, "Oh God, I can't ring the barrister. They're going to charge me, or they'll do this, that, and the other." Whereas I love to have an open conversation, because I sort of feel exactly as you say. Working together to get the best outcome. So and I think that's so important.
Well, thank you very much.
You're very welcome.
And I think we got there, even though we had my poodle barking at one point. We made it. Thank you so much. It's been an absolute pleasure, Trina.
Oh, thank you so much. It's been lovely talking to you guys.
Thank you.
Great.